Hi, my name is Katrina Geddes. I am a PhD student at NYU Law, and the paper I'm presenting at FACT 2022 is The Death of the Legal Subject, How Predictive Algorithms Are Reconstructing Legal Subjectivity. So I want to begin this presentation by starting with a thought experiment. The question that I have is, given the amount of personal data that states and firms now possess about individual citizens, it would not be difficult to algorithmically predict how an individual is likely to vote in an upcoming election based on their spending habits, the nature of their employment, their zip code, and other factors. So if this is the case, why do we maintain the process of voting? Why not abandon the long queues, the voting booths, the ballot counts, and just form a Congress on the basis of predicted votes? Proponents of democracy would regard this question as absurd. Of course, legislatures should be formed on the basis of actual rather than predicted votes. But what are the reasons for this intuition? In the context of criminal sentencing, judges routinely rely on algorithmic predictions of future behavior to determine the duration of incarceration. If an algorithm classifies a defendant as a high-risk recidivist, a judge may incarcerate that defendant for a longer period of time. This extended imprisonment will deny the defendant the opportunity to disprove that prediction through their autonomous actions. So if we can accept the autonomy eroding effects of algorithmic prediction in criminal sentencing, why not form a Congress on the basis of predicted votes? Is it because we believe that criminal defendants deserve to forfeit their future autonomy? Or is there something deeply unsettling about the idea of losing our causal efficacy in the world? If electoral outcomes no longer depended on the embodied act of voting, but upon the correlations observed in large data sets. I start with this thought experiment because it helps to situate my research and the perspective from which I'm coming. I'm interested in interrogating the normative and epistemological consequences for legal institutions of a world in which embodied action is less consequential than algorithmic predictions, because that is the logical conclusion of our current technological trajectory. Across a range of settings, legal decision-making relies increasingly on predictive algorithms to determine individual rights and interests. As judges turn to algorithms to guide their decision-making, the legal subject is increasingly constructed from algorithmic knowledge, so that qualitative information about an individual's circumstances, the rich contextual nuance of their lives, is increasingly discounted and displaced by objective statistical predictions. To give you an example, the reasons why a particular defendant might not reoffend, for example, because of their relationship with their child, their ties to a faith-based community, their determination to become sober, all of these reasons become less important than the statistical features that they share with people who have reoffended in the past. So this displacement of qualitative individual knowledge with algorithmic predictions diminishes the participation of the legal subject in the epistemic processes that will determine their fundamental liberties. Given the impenetrability of algorithmic models and the strength of automation bias, it is difficult for legal subjects to counter the prejudicial effect of algorithmic predictions. When predictive models are framed as expert systems on human behavior, epistemic authority is transferred from the individual whose behavior is being predicted to the data capitalist, whose predictions now form the basis for decision-making. And this epistemological prioritization of data deprivileges the embodied subject as a source of knowledge about themselves. It positions data capitalists as essential intermediaries, translating the embodied experience of living into corresponding data sets. This means that forming intentions towards future action is no longer a profoundly embodied experience, taking place within the human mind, but a disembodied and dematerialized process of identifying correlations within large data sets. To give you an example, consider an algorithmic prediction of parenting quality. An algorithm will incorporate various public and institutional data points about a particular parent. Are they single, married? Are they a homeowner, a renter? Have they applied for social welfare? Have they ever been evicted? What is their credit score? But that model will miss all the other ways in which a parent cares for their child, for which no quantitative data exists, creating a lopsided situation in which negative public institutional data is given greater epistemic weight than the unrecorded experience of parenting. The algorithm creates its own metrics of parenting based on what is accessible to quantitative measurement, and thereby invisibilizes the lived experience that it claims to be able to understand and also to predict. What I think is that this represents a seismic epistemic shift in what counts as knowledge for the purpose of legal decision-making. Zooming out a little bit to look at the institutional effects of this shifting epistemology on legal institutions, using algorithmic knowledge to understand and construct the legal subject, I think destabilizes a core epistemological foundation of law, which is that legal subjectivity has traditionally derived credibility from its close approximation of the underlying individual, through careful evaluation of their mental and physical autonomy prior to any assignment of legal liability. And this is the culmination of centuries of Enlightenment and utilitarian philosophy about agency and free will, as well as advancements in the fields of psychology and psychiatry, which gave us tools to evaluate and treat someone's mental state and generated a more psychological view of personal responsibility. Now, it wasn't always like this, right? In pre-modern societies, criminal liability turned on assumptions and stereotypes about a person's character based on their reputation within their local community. Trials were carried out on the basis of local hearsay, and no effort was made to inquire into the defendant's state of mind. Today, the contingency of criminal responsibility on mental autonomy is so deeply ingrained in the moral legitimacy of the criminal law that strict liability offenses are mentioned in hushed tones as an embarrassing and uncivilized exception to the general principles of criminal law. In contrast, algorithmic subjectivity derives epistemic authority from population-level insights. The algorithmic model is not concerned with understanding and representing a particular individual. It is only concerned with sorting individuals into risk categories for population-level control. For that purpose, the algorithm doesn't need to carefully evaluate your mental and physical autonomy. Your behavioral propensities can be statistically preempted, just as your future autonomy can be inferred from the historical behavior of your statistical peers. Algorithmic subjectivity is not concerned with or constrained by the physical boundaries of the embodied legal subject, their physical actions, and their subjective mental states. The model is designed to overcome bodily boundaries to information acquisition. And because algorithmic technologies dispense with the need to interrogate a legal subject's mental and physical autonomy, this produces what I call the death of the legal subject, or the emergence of new algorithmic practices of signification that no longer require the participation of the underlying individual. And I think this actuarial project is fundamentally incompatible with the law's normative commitment to individualized justice. So why should we care? Why should anyone care about this? At a very high level, if you are someone who values autonomy, the reason this matters is because the autonomy eroding effects of predictive profiling are not limited to criminal defendants. Algorithmic profiling is already diminishing autonomy across a range of decision-making settings, from healthcare and housing to education and employment. There are AI tools that claim to be able to predict how trustworthy an employee will be, how much of a security threat they're likely to pose to their employer, Obviously, these are fundamentally dehumanizing. People are more than a risk score. People are their choices, their feelings, their traumas, but more importantly, standing as we are in 2022 on the precipice of the metaverse, we as a society have to be able to anticipate the normative and epistemological consequences of an increasingly datafied world, a world in which embodied action is less consequential than algorithmic prediction. As predictive models become more sophisticated, data scientists will continue to associate the disembodiment of information with its objectivity and to overlook the important contextual work performed by the resistance of materiality. In this virtual world, electoral outcomes could ultimately depend not on the embodied act of voting, not on standing in line for hours to decide who you want to be your political representative, but just on the correlations observed in large data sets. Faced with this prospect, society will need to decide as a collective what counts as knowledge within the contested terrain of political and legal decision-making. Which decisions, if any, should be based on embodied action rather than predictions of them. Within a decision matrix, is autonomous conduct epistemically equivalent to algorithmically predicted conduct? And if the answer to this is yes, does that mean that for certain segments of the population, their future autonomy is just not worth preserving? The second reason that you should care is because reliance on predictive algorithms has been shown to reinforce and perpetuate inequality. By now, everyone is very aware that Equivalence risk assessment tool overpredicts recidivism for Black defendants and underpredicts recidivism for white defendants. And through this unequal distribution of future potentiality, the algorithm splits the future into two racially distinct times: a white time that is futurally open and indeterminate, and a non-white time that is futurally closed and predetermined. So judicial reliance on predictive algorithms has the potential to sustain the actuarial imprisonment of marginalized communities through data determinism. The second way in which predictive algorithms perpetuate inequality is by focusing reform efforts on individual behavior rather than structural and systemic reforms. So because predictive algorithms claim to be able to predict an individual's future behavior, they perpetuate false optimism about the efficacy of individual level interventions, when many social problems like crime cannot be solved without addressing the underlying structural causes. Mass incarceration, for example, cannot be explained by individual pathology, and it cannot be solved through individual level intervention. Crime is a deeply social phenomenon sustained by cultural, political, and economic forces that lie outside the control of any one individual. But risk assessment tools urge us to focus on the criminogenic features of individuals rather than the circumstances that shape and constrain their behavior. Because these structural features of the world are not legible to the algorithm, it treats them as fixed constraints. It reproduces what it considers to be unchangeable boundary conditions rather than reimagining what those conditions could be. Investments in, for example, education, housing, healthcare, all of these things would radically alter baseline conditions of inequality, and thus the propensity of certain individuals towards specific behavioral outcomes. But the algorithm can only conceive of social possibilities in line with its technical capabilities, so it ignores such investments as targets of intervention in favor of discriminatory profiling practices that actually require the persistence of existing disparities in order to be effective. So in conclusion, does this mean that we should ban the use of predictive algorithms in judicial decision-making? Unclear. The utility of predictive algorithms in modern jurisprudence is a very complicated question that lies beyond the scope of this paper. Even in the narrow context of criminal law, it is very hard to reach a firm conclusion about their net utility. The benefits of risk assessment tools at some decision nodes, for example, diverting low-risk offenders from pretrial detention, are very difficult to weigh against the harms generated by their use at other decision nodes. For example, the exacerbation of racial and socioeconomic disparities in sentencing. And this analysis is further complicated by shifting empirical evidence, as well as the conceptual incoherence of criminal law itself. Obviously, the conceptual coherence of the criminal law depends on your philosophy of punishment, but in general, incarceration for uncommitted crimes, which is effectively the outcome of incapacitation, is normatively inconsistent with the contingency of punishment on proof of autonomous conduct. So criminal law has always been plagued by this tension between its twin desires for, on the one hand, deterrence, and on the other hand, retribution. So instead, what I'm trying to achieve in this paper is to generate a conversation about the underexplored and generally overlooked epistemic effect of algorithmic knowledge on legal subjectivity. How is the basic unit of liberal society transformed by the epistemological prioritization of big data? How are they differently represented? And is the actuarial project of algorithmic governance fundamentally antithetical to the law's normative commitment to individualized justice? Thank you.